Okay, we're at the top of the hour. We're going to get started on this. This is Welcome to Resolve's summer office hours. My name is Kyle Claussen. I'm the CEO of Resolve. We have Bryce Krieger, who is another one of our lead attorneys at Resolve here, and we are going to chat for just a couple seconds on five contract pitfalls that we're seeing in 2026, and then we're also going to just turn it over to questions for anybody that's on. We would encourage you to use the Q&A portion of Zoom, but you're also welcome to come on and ask your questions, live if you'd like to. And a quick disclaimer, just as a reminder, none of this is going to be specific legal advice for your situation. We need to see your documents to give you that specific advice, but we're happy to talk through any questions you guys might have. So with that, Bryce, how you doing?
Doing well. Thanks for having me. Excited to
Yeah,
do this.
yeah, of course, man. Well, let's get started with a couple things that we're seeing in contracts right now, and from the last class 2026 contracts that came through. A couple things that I had on my plate. I'll get your thoughts on this, but we're seeing some differences in termination clauses this year with some discretionary language that's new, maybe with some lock-in periods that are different. What are you seeing in the termination sides of contracts?
Yeah. Well, first off, you have to think about some of those termination without cause, right? What is the ability to terminate you for effectively any reason at all? That will be common. We'll see that, but we want to make sure that the physician's ability to terminate is also similar to the employer's ability to terminate, right? You don't have a situation where the employer can give you 2 weeks notice, well, you have to give 180 days, right? That shouldn't
No.
be the case. Should be the same. But also, and sometimes even more concerning, are some of those for cause termination events, right? Because that has further implications on, really the career. I, you want to try to remove as much subjectivity as possible, right? That sole discretionary type language, or maybe it's productivity based, for cause termination events. We don't want to see that, and we've started to see that a little bit throughout the year. So you really got to check for subjectivity, right? Want to make sure it's objective standards, right? Serious events, not just something where out of whim, employer determines we no longer need you. We're going to terminate for cause, so we don't have to give you, 90-day severance, for example.
Yeah. Yeah, I mean, anything that's too subjective in the termination section is usually a problem, right? Because a for cause termination, has downstream effects on your career for sure. You're gonna have to disclose that usually when you're going to get credentialed, at your next job. So definitely want to be careful on that piece. Um, I've also seen a few times where it's, if you're uninsurable from a malpractice, insurance standpoint, with really no definition about what uninsurable means. So, if your premium goes up, right, it's a little bit higher rate than someone else's, is that all of a sudden a for cause issue? And we know that there's malpractice differences in premiums by physicians. So that's definitely something you want to be careful on. And then you mentioned the without cause termination piece. I'm actually seeing a few contracts now that don't have really any ability to terminate without cause. They're kind of locking what I would deem as locking positions in for 2 or 3 years at a time. And maybe you would think, yes, that's a good thing, right? I mean, we don't want the employers to terminate either during that first couple of years, but most often, my experience with clients is that they want to leave before the employers want them to leave. So, not having that trigger, that lever to pull, definitely problematic. Um, Wanted to talk to a couple other things that we're seeing that's different. Maybe references to data points, and specifically around compensation that aren't up to market. How often are you seeing specific data sources referenced in contracts, and then also how often is that data current?
Yeah, I mean, it becomes a lot more prevalent, I would say, in compensation plans, right? Maybe they'll refer to a compensation plan, and then it's some sort of separate document that describes how they would determine, right? How the employer discretionary determines, or not terminates, but determines compensation moving forward. And then they'll talk about, hey, we use all these different nationally recognized data sources and don't get much more detail further than that. And maybe so it's not recent, or they can cherry pick what they want to determine what that compensation would ultimately become. So I you see it, I would say, a lot of times with larger institutions, right? If it's something that's a compensation plan subject to change over time, and they'll try to keep it as broad as they can. And it's not uncommon to see a situation where it's as the data as they ultimately determine.
Hmm. Yeah, I've even seen references to like we're going to use the 2023 median, from
Mhm.
MGMA's survey or from a blended survey, and I assume most of the people on this call understand what MGMA is. It's a large data set that surveys physician comp once a year. The newest data just came out, and so that's the 2026 survey is now there. But when you look at the details on that, I mean, it's like 80% of the specialties had an increase just from last year to this year. Some of them are pretty dramatic, as we're looking at it, 15 to 20%. And so if you're using a survey that's 3 years old, right, let alone even 1 year old, you're probably at least at a 5% to maybe 30%, right, deficit from where you should be. So I agree that that's problematic and not keeping that stuff up to date. And then the last one that I wanted to talk on before we start taking questions is just non-competes that are changing constantly. What are you seeing in documents now with non-competes?
Yeah, well, it's a shift nationwide, on the statewide basis, but nationwide, a lot of these states are starting to create legislation that is much more beneficial for physicians, right? I would say we're moving in the right direction for physicians and non-competes, but there's still a lot of work to do, right? It's maybe a small majority, right? States still allow for them. In that, right, we've seen legislation which recently where they talk about how, non-competes are validated that are signed, before or after rather a certain date, right? So your non-competes, and
Right.
the employers are trying to shove on, non-competes, get people to sign prior to that date, so that way later on, right, they can enforce that against the physician. So states are making progress, but unfortunately, we're still seeing those non-competes in states that allow for them,
Yeah.
or if there's a deadline, right, that employers need to have a non-compete signed by that they try to get that in quick before that legislation takes effect.
Yeah. I mean, we just to flush that out a little bit more, we've seen some states where they'll say as of July 1 of 2026, non-competes are no longer allowed, but within that law, they also recognize that any non-compete prior to that, right, is going to be valid and upheld because they don't want to go back and invalidate contracts that were agreed to 2 or 3 years ago. And so some employers that know that that's coming, they're saying, hey, sign this contract quick, right, before July 1, so that way we get to continue to have our non-compete in place. So you have to be really careful on what state you're in and what the rules are to make sure you're not signing something that would be invalidated right a month from now if you just wait. So um, let's go to questions. We're going to be on until roughly 12:30, 12:45 Eastern. And so I want to make sure we get through any and all questions from people that are on here. Um, I'm just going to start going through the Q&A. When should we consider reaching out to a contract attorney during our job search? I'll take this one. I'm just going to say as soon as possible. I mean, I do think you're going to receive documentation earlier sometimes in that process than you might expect. We've had clients, and I can use my wife as an example. She's a physician. She had gone on interviews and gotten a letter of intent presented to her at the interview, right? So, I mean, you may get something the very first time you talk to someone. Certainly not every time, but sometimes that may happen. So, I think if you understand what you're going to be asking for, what the data looks like ahead of time. Maybe talk to Bryce or I or anybody else on the team, prior to getting a document. I think that's going to be helpful for you. But certainly once you have anything in writing, whether it's a letter of intent or a full contract, you'd be looking to engage with somebody at that point in time. Another question on termination without cause. Dr. Lal, did you want to come on?
Yeah, hi, can you hear me?
Yeah, we can.
Hi. So basically, last week I was given a 60-day notice, which is part of the contract by the employer. What specific question I had was that, I started here last year and, we didn't get started. I'm a general surgeon, so my job started June 1st, but I couldn't start operating or using the operating room till November. We didn't have staff in place and other stuff. And then I they kind of called me this. We have a new CEO. He called me and said, hey, we're not doing so well. Let's look at opportunities out there that we can get better, go to other places and everything. And then within a month, they gave me the 60-day notice.
Mm,
Also, the question also was that, the operating room that I work in has some structural issues, meaning that they don't have chillers, don't have, working AC sometimes, and then it becomes a problem with humidity and things like that. So there's some technical issues with the OR which has prevented me from doing cases at the time, and I wanted to even when I was doing them. So the question is that, there was no, the only reason that the CEO told me, and he did not write this, he just said, hey, we're just going to move in a different direction. We have to reevaluate the program. But the problem is that, I technically started in June, but started operating in November and seeing patients in November. So I don't think I've been given a fair shot in terms of trying to get this program off the ground successfully. And I don't know whether, I have any cause for redressing it in any legal way, or should I just move on and not cause any problems?
Well, I guess my thoughts on that are if they terminated without cause, and that's a mechanism that's in the contract for them, they didn't do anything wrong necessarily procedurally. I mean, they're not in breach of contract for doing that. Now, that being said, if they didn't allow you to, perform the duties that you were supposed to, they didn't provide the right staff, the right equipment, right things in the right situation for you. I mean, certainly you could take the position that they're in, breach during that time frame, but you'd only be looking at losses right during that month or two that you were with them. That is the up and the down to having a termination without cause. Is if it's in the contract, they're allowed to use it just like you are, right? And so if you change your mind 2 months in, you're also able to get out of the contract, which is usually the benefit, right, of those provisions.
Yeah.
It may be, again, I can't give you legal advice on your specific situation right now, but I do think, sometimes in those situations, it's better to cut bait, right, and kind of move on, right, rather than drag something out for a damage amount that might be pretty minimal.
Yeah. Okay. Got it. Thank you.
You bet.
And to piggyback off of that too, I think that also shows the importance of looking to get exceptions right into your contract for what happens if an employer does terminate without cause, right? If they provide a signing bonus or some sort of upfront funds, right, for you to come into this position that you wouldn't have to repay, right? Those amounts at that type of situation too. So there's other financial implications, right? Other mechanisms, termination mechanisms that can be implicated with the termination without cause. And since you can't control that, you want to make sure you're protected with those situations too.
Yeah. Okay. Thank you.
You bet. Okay, here's an anonymous question. How do physicians counter the hospital strategy of we're losing money on Dr. X based on work RVUs? Meanwhile, physicians generate so much more downstream revenue for the hospital. Bryce, what do you think about that? We're losing money on physician services.
Yeah, well, funny how they phrase it, right? They're aware, right, of downstream revenue, right, and what those positions mean for them. It's just a way, a mechanism of them trying to, move the goalposts, right, on physicians. That's where I think data becomes very helpful, right? Hey, this is, approximately median, right, in terms of productivity. Regardless if you're losing money on that, that's not my issue, right? Ultimately, I should be compensated accordingly, right, for my services, for my productivity. They're aware, right? They're not going to come out and explicitly state, hey, yeah, we're receiving so much downstream revenue, but right, they're inherently aware of that aspect of the situation as well. And so I probably wouldn't entertain, right, or really try to argue so much about that, the revenue or profits or losses that, the individual physician earns, but more so try to compare it to what is out there in the market.
Yeah, I mean, there's certain when we look at data and the physician fees, right, and what you're reimbursed on physician fees is very different than downstream facility fees or technical components that are out there, and so there are certain specialties that generate more margin on the physician side, and there's certainly some, and anything that's surgical based, right, is going to drive a ton of downstream revenue, for the hospital and facility fees, and so we do see some comp to collection ratios where they're paying out or they're compensating at levels that are very high, right? Almost 100% of your physician fees because they know that downstream revenue is coming. So as an employed physician, it's not really your job to manage the P&L, right, for them. If you were in private practice, that'd be really, really important. But if you're working for a health system, you're not getting the full picture, right, of all the revenues. And I think that's what Bryce is hitting on. And so I think you have to argue for that or recognize that as part of the conversation, knowing that they're never going to document what they're all, generating and earning for you, because there are some stark questions and, some compliance issues with that. But if the market says, pick your specialty, family medicine makes X number of dollars per work RVU, it'd be odd that they're the only ones losing money on that right at that rate. So I think you really just need to lean on the data as much as you can. Okay, moving to the next one. Do you provide any recommendations or referrals for residency program discrimination related cases, or can we go to resolve for these types of cases? We would help you find someone. I mean, if you're going to have a discrimination case, that's litigation that's going to be very local. It's a very specialized area of the law, so we don't do that personally, but we would help you connect with someone. And if you have questions on that, you can feel free to reach out and send us an email. We'd be happy to help you line that up. Okay, Dr. Gupta, you got a question? Did you want to come on? Or I can read it. This is a question on boilerplate contracts with little room for negotiation. Any advice? So, Dr. Gupta, you hopped on. Yeah, go ahead.
Oh, thank you. I just saw that pop up to my screen. Well, first of all, I appreciate all of you giving us this opportunity. I think this is going to be really, really helpful for all of us. More and more, as we move towards consolidation, physicians are dealing with larger and larger health systems and other similar employment models in which there is often a broader boilerplate contract and very little room to make a change or to negotiate. Do you have any tips on how to deal with those contracts? What I find is that they are very suitable to certain specialties, but not as much to others. So any recommendations on how to deal with those? Thank you.
Yeah, I'll give you my thoughts quick, and Bryce, you can chime in on this too. But I do think when you have a system that's large and employing, 50 plus different physician specialties, those are 50 different situations. And so some of them may be paid on shifts, some of them may be paid on work RVUs. We still have some systems that are, bonusing on collections and work RVUs, right, for different specialties. So I think to say that we have a standard contract that is the exact same for everyone is just, it's not true from where we sit. Um, we do see some of the larger systems wanting to adjust or make those kind of customizations on an exhibit. So they may have 10 pages of the contract that are consistent for everyone, and then they make modifications, down below. I think there's different procedural ways to get to it, but um, from my vantage point, and I think Bryce will probably echo this, we do see even large systems making changes to their contracts, whether that's a comp number or language, and where they do it procedurally is different. They may have to create a letter of understanding or a memorandum to attach as an exhibit, but it would be a false statement, I think, to say that all contracts are the same.
Yeah, I would agree. And if you had to put a percentage on that, Kyle, what percent of standard contracts have we seen actual modifications to?
Oh, I think it's 70 to 80%, I would say, are
Yeah.
getting an adjustment somewhere. And that's not that every paragraph's getting changed. So I want to set
Yeah.
expectations on that appropriately. But I do think if you come in and say, hey, I'm okay with the whole contract, but the non-compete doesn't work for me. For example, I mean, I've had a client recently that just wouldn't sign unless it was changed. And sure enough, it got adjusted. So I think you have to prioritize probably in those situations as well, and know if you have leverage. If you have a position that has five really good applicants at this point in time, right? There's five physicians that want the job. They're probably not going to negotiate as much as if it's been a position that's open for 3 years and they have a really hard time filling it. So I think you have to analyze your situation as well. Okay. Um, Next one is, if I'm negotiating a contract 2 years into the future, how should I get them to adjust for future changes? Is there a chance the MGMA comp data ever goes down? And could this hurt me? Bryce, what do you think about that?
Yeah, even if there's not something in the contract about, hey, compensation in 5 years, right? 3 years is going to look like XYZ. It's still something that we would want to see at least review of what that actually is. And so even if you have a 5-year contract or 2-year contract and you have a guaranteed compensation of a certain amount, we have no idea what the data is actually going to look like or what the market's actually going to entail. And so that comes back to, you could add something to the effect of both parties would enter good faith negotiations after a certain time frame, but that is also inherent with the ability to terminate without cause, right? If you have the ability to walk away, right, you can always try to renegotiate. And so, uh, with that, right, I would look to see what your termination without cause ability is. And so if there is a potential chance that MGMA changes, right, for the better, right, you can try to renegotiate. MGMA could go down, but from our experience, not often do we see that.
Yeah. And we're again just looking at the most recent set that came out, and it's about 80% saw an increase. So it's, 1 in 5 chance that it can go down, but a lot of the ones that have gone down are like less than 1%. So it's flat to up for almost everyone. And certainly there's changes in reimbursements and fee schedules that are out there, and that'll eventually trickle down. But over the course of like a 2 or 3 year period, it's extremely rare that your compensation rates are going to go down. It might go down for a year, but it's going to hop back up the next year. So I would say referencing at least a review, like Bryce said, on a certain cadence of every year or two would be the way to try to solve that. Okay. Next question. What should be generally expected when interviewing and negotiating for position? At what point does the negotiation start? Right away. Is the answer. I think everything that you say and everything that you reference in an interview is probably the start of your negotiation. We certainly know that it's hard to recruit and retain physicians. And so we know that they may set you up with realtors. They may have you talk to people in the community when you're there. They're going to have you talk to colleagues. And I think anything that you say as part of that is it's going to come back to the hiring committee, and they're going to have all that information. So if you say, we really love this place, or my spouse has a job, or I've already enrolled my kids in school, right? I mean, all those things are buying signals on your end. And so I think that reduces the leverage that you have. And so I don't want to encourage you not to be interested and to not show that you want the job, but I do think that the negotiation starts very early in the process of showing your cards, and maybe committing to numbers too soon, right? What do you expect to be paid? You say 300,000, well, you've set an anchor, right? Like you're not going to deviate much from that 300,000, as opposed to saying, I don't know, I haven't looked at the data yet, I want to be paid fairly, right? I mean, now you're setting a fairness tone versus a number. And so I think it's early on in the process, which is why we would encourage you to talk to someone, about this, and to be ready for those conversations, even maybe slightly before you get to that document in your hand. All right. We've got a couple more here that are popping on. Oh, they're moving around. Dr. Harrison, do you want to hop on? I think you're next.
Hey,
Hey.
thanks. Sorry. Um, uh, so my question was just about, the term sheet contract process because um, it seems like there's a lot of like fine tuning and details that come out through the contract that's not on this term sheet. But then the feeling is that when you get a term sheet and you agree to it or sort of sign off on it, then sort of the rest is in the bag. Like, do you encounter that? Do you know what I'm talking about?
Yeah, I think so. Bryce, you want to handle that one?
Yeah, we'll see employers, recruiters, right, try to phrase that as, hey, it's a done deal, right? You agreed to the term sheet, everything's, let's get onboarding started and get you going, right? But there is, right, plenty of terms that are going to be later on within that full contract. And I would check to make sure the term sheet or offer letter is not binding, right? That you don't have any type of contractual obligation to them if you were to sign that. But I would want, even if they tried to phrase it in a manner, right, that everything's a done deal, I wouldn't have that expectation that you have to sign, right, that full contract. And so whatever terms that, let's say, are not on that term sheet, but in the full agreement, right, and you're seeing that for the first time, absolutely, that's open for negotiation, regardless of how an employer tries to handle that. Just because of the fact that, right, we hope that you don't have any type of contractual responsibility or obligation to them from the term sheet, and that you don't have to sign that contract.
Thanks.
Okay, I skipped one. Dr. Surignano, I think that's how you say it. You want to hop on?
Yes. So my question is, if it's normal for corporations to include the quality on the base to calculate the threshold. So basically, what the employer is trying to do, they want to do quality and base, divide that by the RVU value to get the threshold that you're supposed to meet. But since the quality it's not guaranteed, is that normal to make you pay for that in advance?
normal probably isn't the right way to frame it. We do see it structured that way, but we also see it structured the other way, where your guaranteed comp is what's setting the threshold and your conversion factor. So sometimes what we'll see is, let's say it's $50 per work RVU, and then there's another $5 per work RVU for quality, or a flat amount, $20,000 a year for quality. Um, at the end of the day, when you look at any survey data, the dollar per work RVU is essentially your total comp divided by your production. So they're not necessarily wrong for doing that, but when it's not guaranteed and you have no control over it, your threshold is probably what's wrong, and it needs to be pushed down to whatever that guarantee amount is, because that you want your total dollar per work RVU to be at obviously at median or above right at the end of the day. And it sounds like the way that they're framing it, having it be, not guaranteed, is going to skew that number.
Right, right. Thank you. Yes.
Okay. Dr. Demko, you're next. Dr. Demko, you on?
Sorry about that. Can you hear me now?
I got you now. Yep.
Awesome. All right. Thank you guys for doing this. I appreciate it. I had a question about kind of safeguarding myself against excessive workload. The last position that I was in, my contract had the other duties as reasonably assigned by the CEO, both under like the directorship position and physician duties. And I think we had some disagreements about what was reasonably assigned. Similarly, like the position wasn't RVU based, but caseload based. I had an expected average caseload of around 13 patients. And by the end of my time there, they were hitting me with like 30 patients a day, despite my pleas to cap me much lower. Are there ways that we can kind of build in protections from having these, other tasks added, uncompensated things? Like this situation was a lot of like stripping away social workers, and then I end up doing that kind of position and role as well. Or is that something that would be addressed more during like renegotiations when the contract's up for renewal?
Yeah, I guess I'd prefer that you solve all that before you start, but it's certainly on any renewal you could also try to renegotiate. Not uncommon. I mean, when we look at any dissatisfaction survey, right, or any like the reports from Bain that they did, it's almost always around work, meaning what you're doing, when you're doing it, who you're working with, what equipment's there. It's not really that you're dissatisfied with comp. I mean, not you specifically, but as a whole, right, for physicians. And so I think if you can get either mutual agreement language in, meaning you have to say yes to the administrative duties, you have to say yes to the schedule, you have to say yes to the locations. If
Gotcha.
you have some veto power, that's helpful. Or you have to be really, really objective with it. And you have to say, I'm only working Monday through Thursday. I'm only seeing 20 patients a day, and I'm only, whatever, going to satellite once a month. So you can
Okay.
do it either way. If you want flexibility, mutual agreement will protect you. If you want to just lock them in and not have any changes, you'd be really specific with it.
Cool. I appreciate that. Thanks very much.
Yep. Okay, Dr. Sadawaska.
Let's see. Can you hear me?
I got you now. Yep.
Okay, perfect. So I had a quick question about termination clause. I have an excessively long termination clause of 360 days. What are my options as far as negotiating it down to less than 360 days, and how would that affect my tail coverage?
Bryce, you want to take that one?
Yeah. To get it less than that, you would need to be fully safe, right, from any potential lawsuit that they would have against you, breach of contract situation. Mutual agreement would be preferable, right? Getting something signed off on by both parties that, hey, we're agreeing to terminate earlier, right, on a specified date. That would be preferable. With regard to how that affects tail coverage and really any of the other contractual obligations within the contract, it depends, right, on what those terms currently are. But then they also may say if they say they pay for tail coverage upon termination, they may come back and say, hey, we'll give you only 180 days if right, you are responsible for tail. So they may throw in monetary contingencies to get that mutual agreement for an early termination date. But that mutual agreement is going to be the safest option for you if you're looking at trying to get out earlier.
Gotcha. So mutual agreement meaning between lawyers of the company and myself, correct? It would have to be negotiated down if I wanted to leave early.
Yeah, written documentation signed off on by you and by the employer, representative of an employer,
Right.
to have that contract terminate earlier.
Gotcha.
My recommendation would be either be an amendment prior to terminating, meaning you negotiate it before you give your notice, or you try to get a separation agreement on the way out that covers that piece.
Separation agreement?
Yeah, and that's the document Bryce is talking about that would be negotiated between, your legal counsel and theirs.
Gotcha. And if the employer essentially refuses, says no, you signed 360 days, we're going to hold you to it, then my hands are bound pretty much by this.
Yeah, then your option is either to work the 360 days and not be in breach, or if you leave early, you're in breach of contract, and then there's potential damages. And then the question is do they chase after you for those damages or not?
Gotcha. So it's really depending on the employer how much they actually want to chase me for the damages. Got it. Okay.
Correct. Yep.
All right. Thank you.
You bet. I think we already answered the 2-year question, so that one can get taken off, Melissa. Dr. Nawarni. Or Nawari. I pronounced that terribly, so you can correct me on however it's pronounced.
Dr. Waneri, hi.
Thank you.
I had a few questions. Thank you for answering them. So my biggest question is navigating contracts with the hospital system because they are not very willing to negotiate terms. It seems to be pretty standard, and they are not as amendable with what adjustments I would like to proceed with. So in your experience, what elements should I look at when it comes to navigating contracts with hospital systems? Should I look at sign-on bonus or loan forgiveness? Like what areas do you feel like they would be the most amenable to discussing? And then how do you navigate a lower than expected income guarantee salary?
Yeah, I think certainly compensation is an area that they will likely entertain to negotiate. And so anything that's a recruitment incentive, like a one-time payment, a signing bonus, relocation allowance, stipends while you finish training if you are in training, student loan forgiveness. We do see student loan forgiveness. It's not as common, I think, as people would think that it might be, but certainly something to think about depending on location. How you negotiate any and all of that, hopefully, is that you've got competing offers. Hopefully, you have 2 or 3 offers to look at, and then also you're going to look at your colleagues' data, right, which would be like the R data on our site or the MGMA data that you can get on our site. And so you'll know going in what's fair and what's not, and that'll help you decide where to push. If they're giving you the standard language, kind of position, and the language isn't as important to you, then I would say focus on the comp. But again, I think it's hard to know without seeing the document and knowing what's important to you. How that language is going to play in, because I think one of the last physicians, I think it was Dr. Demko, really worried about scheduling and patients and all the stuff that happens 2 and 3 years down the road. And so sometimes I do think when folks are signing contracts, they focus on numbers maybe too much and not on the language. So I think you just have to prioritize, but certainly we do see them move. So I think you should have 2 or 3 offers and push for what you need.
For those offers, so in my case, I have offers. One is in the same region, one is not, is in a different
Yep.
city.
Yep.
Should I still allow them to see the offer from the other, and that's in a different city when it comes to negotiating my contract, or is it not as valuable?
Well, not as good as something right next door, right? It's like a comp in real estate. So I think the closer it is in location and also type of employer, right, will really help. If it's academics versus private practice, those are very different as far as what medians would look like. I also wouldn't share the full document with whoever you're negotiating with. I mean, I think there's some confidentiality pieces there. So you could say, hey, here's the terms of it. But I don't know that I'd give them the full document.
Awesome. Thank you.
Yep. Okay, I'm just going to hop down to one here. What do employers actually offer when they say student loan repayment assistance? How does that actually work? Are there several different ways to go about it? Bryce, how have you seen student loans handled in contracts?
Yeah, I would say normally it's going to be on a yearly basis. We will see sometimes a large sum being provided, right? A large one-time payment, but that's going to be subject to some sort of commitment period, 3 years, 5 years, however much, right? Most often, I would say it is going to be a reimbursement up to a certain amount that they're going to provide on a yearly basis, whether that be 10, $20,000. That's probably going to be the most common structure, and often they're going to have that built in as a reimbursement, right? Basically, have to prove receipts that you had made that payment to your student loan servicer.
The only, yeah, and I agree with all that. The only caveat that I would add to it is that I think you do need to remember that student loan reimbursement is taxable to you. So I think sometimes people think, well, if I can shift the signing bonus over, I want to pay tax on it. There's a very small amount that's tax free, right? Like the first $5,000, if the employer elects to do it that way. But almost all of that is going to be taxable income. So if it's all taxable income, I think you need to think about whether it's more beneficial just to have it to utilize, whether that's for a down payment on a house or other higher interest debt, or if you actually want it going to your student loans. So try to think about your compensation package as a bucket, right? Of here's all the things that are going to come to me, and obviously there's different tax consequences on some things, like you know your health insurance, right, might come to you tax free, but most things are going to be taxable, and so shifting it to what makes sense for you is really important. Um, well, I'm going to hit the last one because it's really easy. Where do I find MGMA data for radiology and or breast imaging? You can find that on our site. There's snapshots available for a very low price point. There's also custom data, which is probably what I'd encourage you to look at because when you sort any data set, and MGMA is certainly one of them. I know there's some sites that are giving this away for free. That snapshot is not going to be as useful as digging in and saying, hey, what is right the 55th percentile in my state, in my area, based on whether it's rural or metro, right? Digging into the details can shift your comp, 10 or 15% at times, and on your compensation levels, that's a really big number. So you can certainly go to Resolve and find that data. How do you navigate accounting for work done in training, supervising, mentoring residents as part of a compensation in terms of work RVU threshold in an academic setting compared to a community-based primary care, since you spent time with residents it's not accounted for in RVU generation? Yeah, I mean, I think anytime you're training anybody, right, whether it's a student or you've got a resident with you, that's taking time, right, away from you. And so usually in an academic setting, you're going to see an FTE allocation for teaching, right? So it might be like a 0.2 allocation, which means your work RVU threshold should get dropped also by that 0.2, time allocation. So 80% essentially of what somebody in community practice would see. So I think it just depends on how much time they're taking up, if they're making you more efficient or less efficient. But certainly you're going to want to start to tier back and kind of weight your thresholds appropriately, or that would be my recommendation. Bryce, you have any other thoughts on that?
Yeah, and I think that again, keep coming back to that can be helpful. I know MGMA, I believe, categorizes how much clinical time, right, and academic reports as to what work review productivity can be too. So just accounting for that, seeing if there's different filters that can, show what is reasonable for your situation.
Yep. Okay, my contract includes a non-compete restricting me from practicing in my county after leaving my employer. How enforceable are these physician non-competes in practice? What are the most successful strategies for getting out of them or challenging them if I want to continue practicing locally? Bryce, what do you think?
Give a classic attorney answer. I'm going to say it depends. So it depends on the state, right? It depends on what different case law is for that situation. Again, laws are changing for the better, but they can still be enforceable. And so, one way, right? I've seen buyout type situations. Now, it can be a hefty sum of money that they would be asking for a buyout, but that can also be part of the new employer, right? Seeing if the new employer is able to help out in that negotiation or fund some of those amounts to buy out a potential non-compete. And so that's probably the most common situation I've seen is some sort of monetary value in order to not have to worry, right, or to waive that non-compete for that new employer.
Yeah, the question you're going to have to answer is, are you willing to challenge it? Because if it's in your contract, that's going to be the default, right? So to not comply with a non-compete, it's either going to have to be wiped out by a judge, right? This is unenforceable, or to Bryce's point, you're going to have to agree to buy it out at a certain level. And so for a judge to think it's unenforceable, it's got to be too broad, right? It's got to be too restrictive for your specialty and for that area. And so depending on the county size, depending on what your practice type is, and you know, the example there would be like hospitalist versus a dermatologist, right? A dermatology practice builds up a patient base, and that patient base will likely follow the person right across the street or within the county. If you're a hospitalist, are your patients going to travel with you? The answer is no, right? And so I think it's more likely to be enforced in the dermatology example. So it really depends on state, it really depends on practice type, and it really depends on size of the county, right? And how big that is. So we'll move on from there. And we've got about 5 minutes left. So if you have any final questions, feel free to plug them in. If you use your name, I think we'll have your email from the Zoom, so we can try to answer them that way as well for you. But have we seen any contracts written essentially for essentially part-time, even somehow capped to 30 to 40 hours per week or 2 to 3 days per week? Does it differ by specialty or region, et cetera? The answer is yes. We see anywhere from, like what I would call a 0.2 FTE, so kind of a 1 day a week, all the way up to full-time 1.0 FTE. We certainly also have full-time, kind of in quotes, full-time that's done over 4 days a week, right? It's Monday to Thursday, with no distinction in, compensation adjustments or anything else. So it does differ by specialty, it does differ by region, but also differs on what you've negotiated up front and what you want. If you're coming in and asking for a part-time position, I think a lot of employers will be open to that as long as it's the practice type and style that can support it. What are real options for setting up lower schedules, part-time contracts? I think we just got to that one. The answer is you have to ask. They're available. You may not get all the way to, let's say you want 2 days. That might not be available. You might get to 3 or 4. I think you just have to start the conversation. What can we do as an employee, hospital employee, when the hospital establishes a partnership with a medical school, and now we will be in an academic role with GME training and the responsibilities that this comes with regarding how can we be fairly compensated for that? The university has claimed to a large physician audience they do not pay for this. Yeah, I mean, you should be paid for it one way or the other, and that may be paid with time, right? Meaning you're cutting back your clinical schedule, or you're moving to a 0.7 FTE clinically and a 0.3 for teaching, or they may just pay you more, right, for essentially supervising and providing that service. So I think you need to be paid for your time, one way or the other, right? It's either dial back my patients or pay me for the work I'm doing. I think we already answered the other one on there, Melissa, from Rachel. And the last one up top here, my contract includes a non-compete restricting me from practicing in the county. We already hit that one too. Right on time. 2 minutes left. Any final questions? Okay, well, if not, we are doing these twice a month. So we will do another one in 2 weeks. You can go to the Resolve site and click on the Attorney Office Hours tab. If you found it helpful, we'd encourage you to tell your friends and colleagues. We're happy to do this and answer as many questions as we can in 45 minutes. So appreciate you guys hopping on, and we'll talk to you in a couple weeks. Thanks.